Well, Judge Kavanaugh was the one in the hot seat today, but it was the president often taking center stage during the hearings for his second Supreme Court nominee. Personal attorney for the president and Supreme Court advocate himself, Jay Sekulow, is here to weigh in on what we saw today. Good evening, Jay.
Hi, Shannon. How are you?
I'm good. I want to play a little something, first of all, with the ranking member, Senator Dianne Feinstein, the top Democrat. Here's her interchange with the nominee.
Can a sitting president be required to respond to a subpoena?
Going with the Justice Ginsburg principle, which is really not the Justice Ginsburg alone principle. It's everyone's principle on the current Supreme Court. And as a matter of the canons of judicial independence, I can't give you an answer on that hypothetical question.
And, Jay, you know he was asked a lot of other questions, including by Senator Blumenthal, who said, I want you to promise to recuse on any case that would come before you involving the president. Is it posturing, or are these legitimate legal questions and concerns by the Democrats?
Well, they're not legitimate at all. Let me say, I've argued in front of the Supreme Court for over 3 decades. And the idea that a nominee of a sitting president would have to recuse himself involving cases that might involve the president or policies of the president would mean justices would be recusing themselves on every case. So that's absurd. What is Brett Kavanaugh going to do? If a case comes before him, he's going to review the briefs, listen to the oral arguments, and make a decision to defend the Constitution of the United States as he views the Constitution. That is what we expect of Article III judges. That is what we expect of Supreme Court justices. And, you know, I noticed on some of the other networks, they were talking about this, you know, Brett Kavanaugh having a grilling is what one of the networks said today before the Judiciary Committee. Now, I know, Shannon, you've been covering this for a long time, and you've been covering it today and very thoroughly. But there was no grilling of Brett Kavanaugh. In fact, Dianne Feinstein had to come in at one point to correct Senator Leahy, who was pointing out, trying to cross-examine, so to speak, Brett Kavanaugh with a document saying there was a reference to him in this particular document. And when everybody looked at it, and Senator Leahy finally was told that it doesn't reference the nominee to the Supreme Court, and it was Senator Feinstein that says he's not in it. It's not there. Oh, okay, let's go to the next document. So the lack of preparation, this is a lot of show. The fact is, under the Constitution, Brett Kavanaugh has a job to do when he is confirmed, and he will be confirmed as a justice of the Supreme Court, and I suspect before the first Monday in October that he will be a justice on that court. And the fact is, he reviews the law, reviews the facts, listens to the arguments, and makes a decision like every other justice in the Supreme Court.
And I talked to Senator Lee, a member of the Senate Judiciary Committee, who questioned Kavanaugh today as well, probed him on a number of issues. I also talked to him about this story today about this senior Trump official who has this anonymous piece in the New York Times, and whether it's fair for someone close to the president or in his orbit to make these kinds of claims. Here's what Senator Lee told me.
I think it's kind of odd for somebody to stay in under the false pretense that they're there to help, that they're there to be a part of the administration if they're actively undermining it. Now, if they see things that are wrong, that are illegal, that are immoral, they ought to leave.
Are you worried that there are people around the president who don't have his best interest at heart?
Look, I'm not going to comment on Anonymous. I mean, let's start with that first, okay? Anonymous is doing an op-ed. You know, it's one thing you got anonymous sources, an article. This is an anonymous op-ed. So, you know, to me, looking at this as the president's lawyer, this is, I mean, look what's going on right now. We've got a nomination to the Supreme Court of the United States. You've got international issues that are very significant involving China and Russia and North Korea, and we're talking about Anonymous. Now, let's just focus on that for a moment. We're talking about an anonymous op-ed in the New York Times. So, I mean, let's think about this for a moment, Shannon. You and I have been talking about a Supreme Court nominee that will serve for life, that will have an impact on the Constitution of the United States for decades, which is what they're supposed to do. And instead, we're now talking about Anonymous. So let me tell you what my answer to Anonymous is. I'm not talking about Anonymous.
Okay. With that in mind, listen, when I was a practicing attorney, I much preferred interrogatories, written questions for my client. I know these are things you're negotiating. You can't talk about the substance of what you're talking about with the special counsel, but can you give us a timeline that you think this might be resolved one way or another?
Well, let me tell you what I don't give. And you know that from me, you've known me a long time. I don't give timelines. Look, I think it needs to be wrapped up soon. For the good of the country, for our national security interests, just to get this investigation done. This has been the most transparent inquiry of a White House in history. 1.4 million documents, over 30 witnesses that were put forward by the administration. This was as transparent. I mean, I don't think Bob Mueller would argue that this is not transparent. So it's very transparent. Now, when you get down to the question of where we are now, I'm not going to, as you said, I'm not going to, our policy is we're not going to comment on ongoing dialogue that we have with the Office of Special Counsel. I'm not going to breach that here. I wouldn't do that. I will tell you this, though. Obviously, there's a process that you go through. We've looked at this historically. There's other, a lot of administrations have had these kind of inquiries before, and you handle it in an appropriate way. Our job, my job, Mayor Giuliani's job, the Raskins, our legal team's job, is to defend the president. That's our job of what any lawyer would do in a situation like this, and we're going to do recommend what's in the best interest of the president, what we think is the appropriate review here, and I'm hopeful that it will be resolved sooner rather than later. That's about as good as I'm going to say. That's about the date I'll give you, sooner rather than later.
Okay, we'll take it. Jay, keep us updated.